Thank you, everyone, for being here today. Good morning, and good afternoon from other parts of the world, and good evening wherever you happen to be. I My name is Sean Timmons. I'm the managing partner of Tully Rinckey's Houston, Texas office. I'm also, handling military cases around the world. I handle a practice consisting of military criminal defense, military administrative matters such as boards and medical evaluation boards, so separation boards and medical boards. I also handle a lot of federal civil litigation cases involving employment discrimination claims concerning veterans specifically. I handle USERA, I handle arbitrations of employment mobility claims, I handle regular Title VII discrimination claims throughout the state of Texas. So my practice is quite diverse. Today, we're going to talk about my one of the things that got my attention, at the firm and helped grow my practice and career was some of the victories in cases that the odds were very much against us. So I wanted to put together a presentation with a description of some of the lessons learned that I found in common patterns when it came to multiple cases that I experienced good positive outcomes from. So today's topic, again, invite everyone to read more about me. Again, you can go to the website, tullyrinckey.com. You can click on attorney profiles. You can read about me. And I'm licensed to practice law in the state of Texas, the state of New York, Federal District Court in Colorado, the Federal District Court in Washington, D.C., the Fourth Circuit Court of Appeals, the Fifth Circuit Court of Appeals, multiple other federal courts throughout the country on a pro hoc vice admission, meaning special permission from the court. And I'm appearing in lawsuits throughout the United States and in court martials around the globe. I've had trial experience in 7 or 8 countries by now. I have appeared for Tully Rinckey this particular year alone on 8 international trips. So I spend 120 approximately days per year on the road. The rest of my time is bifurcated between Houston and Austin. Most of it in Houston, but occasionally I'll pop into Austin and be there for a few days out of our Austin office. So I would say my time is probably spent 50 to 60% of it at home. The rest of it is on the road somewhere around the world. So I utilize a lot of time management skills to try to acclimate to wherever I happen to be and manage accordingly. But I could go back to a lot of the same places routinely, such as Navy Base San Diego, Fort Bragg, North Carolina, the Washington, D.C. metro area, all over the state of Texas. There's a lot of installations that have a lot of frequent activity, so I appear at those places quite a bit. I also have had a good number of cases in England and in Germany. So let's go on to topics for today now. Discussion of what I find is what I've looked at as what I consider routine mistakes by the prosecution. In the Air Force, I find what they have done is be arrogant. The Air Force considers a turn down of non-judicial punishment known as Article 15 as, and this is what they describe it to me as, so I'm using their words, and I'll quote it, spit in the face. If you turn down what we just consider you deserving of an Article 15 and you demand trial by court martial, they get very emotionally aggrieved and they take the case to trial. Even if the facts don't warrant prosecution, they see trial as almost practice for their attorneys who don't have a lot of experience. So in factually weak cases, if you turn down a commander's recommendation for an Article 15, they will take it to trial. And if the facts do support your acquittal, you will get acquitted. Acquittal rates are high in the military. And in the Air Force, they're very high because they prosecute stuff that, quite frankly, should not have been prosecuted. And quite frankly, the Army and Navy probably would have just taken it to an administrative separation board where the standard of evidence is much lower, and they would have disposed of the case that way. The Air Force takes it all the way to a criminal trial because, again, they're arrogant and how dare you turn down the 15? How dare you, not just accept responsibility? How dare you make us go to a trial? Well, nobody's making them go to a trial. They're going to the trial out of their own choice. And that's been their policy and procedure for a very long period of time. So the Air Force generates a lot of business in my practice, and I've had more Air Force trials than any other branch, probably because of 2 reasons. One, the Air Force tries a lot of court martials, even though they're a smaller branch. And 2, people generally have financial means who are part of the Air Force, so they can hire private counsel. To be blunt, a lot of people who join the Air Force come from higher socioeconomic backgrounds than other branches because it's more difficult to get into the Air Force from a credentialing perspective So you see people with resources hire private attorneys in the Air Force more. Statistically speaking, I've represented people in every branch: Army, Marines, Navy, Air Force. However, if you look at my entire history of court martials, I have appeared at more Air Force installations than any other branch of service. And I've had a significant number of full acquittals in Air Force cases from Article 15 turndowns in prosecutions that never should have happened. Common theme for the Army is, ineptitude, incompetence, witness credibility, lack of preparation, lack of considering alternate dispositions in the prosecution, just checking boxes, not preparing witnesses, and just showing up at the file. And I think cultural problem too. In the Army JAG Corps, and I served 4 years in the Army JAG Corps. I had a lot of great experience there, and I really value my time, my opportunity to make friendships for life with many colleagues. So I don't want to disparage the Army JAG Corps, but I do want to mention a factually true statement. Is in the Army, there's a culture that they really don't care how good of a lawyer you are. They care more about how good of a soldier you are. Well, you have to be both. You have to be a soldier and a lawyer. But many attorneys get into the culture of caring more about having airborne, air assault, Pathfinder, special forces tabs, different advanced military specific courses than they do about their legal competence, because they really want to advance like the rest of the Army officers and have those distinguished patches, those medals, those certifications, those credentials. And it looks pretty cool to have an airborne patch on your uniform. People give you accolades for that. So if you're focused on airborne school and not on legal practice, you may not prepare for trial. In fact, you may be focused more at the gym on physical fitness than reading cases. And I see that in the JAG Corps time and time again. I see a lot of attorneys like me who are very academically focused, and lack of better terminology, quote unquote nerds, or what people would say is, a little awkward because they're so smart. You see some of that in the JAG Corps, but you see more of the grunt gym guy who just cares about weightlifting and being in shape, and reading cases and preparing for trial. That's neglected. So that demonstrates itself in trial when they have not prepared. When you talk to them during trial, afterwards, what's going on next week? Oh, next week I'm going to air assault school. Oh, great. That actually gives me really good hope that the case is going to go well, because if they've been preparing for air assault school for the last 2 months, they probably haven't been looking at the file very closely. And then that shows up in witness direct examination. They haven't really vetted their witnesses out. They haven't really done their job sufficiently because, again, they're dual obligated. They're focused more on their, going to their training and their military career than they are their legal academics. So that's a difficult balance, and we use that to our tactical advantage. Yes, I care about physical fitness and my health, but my focus is on the case and preparation for trial and getting an acquittal for my client, not on, am I going to go jump out of a plane next week and am I ready to do that? I'm not worried about that. I'm worried about defending my client fully. In the Army, unfortunately, a lot of attorneys within the JAG Corps focus more on that than they do their own legal skills, which is to our advantage. Common theme: Marine Corps mistakes. A similar problem. In Marines, you're also, if you're a Marine JAG, you can be a company commander for a platoon unit the following assignment. So you bounce between positions. Every Marine is also a rifleman. Every Marine is a rifleman, is also rotates jobs. So you don't just stay as a lawyer, you may do other roles. So that loses your skill set. These prosecutors that have to bounce through that may neglect their duties as a prosecutor. And, they do a sloppy job preparing for voir dire. They do a sloppy job preparing witnesses and actually examining the facts, rushing through cases, and simply hoping that the sheer volume of activity will offset the deficiencies in their presentation. That's been my experience with the Navy and Marine Corps. The Navy, in my experience, has been the most forgiving service of misdeeds, meaning generally panels in the Navy, in my experience, are generally more forgiving with what I'd consider shenanigans, minor misconduct, drunken disorderly behavior, reckless, stupidity. The Navy is by far, in my experience, having done a significant number of trials for Tully Rinckey in private practice of all branches, and in my opinion, I think the Navy is the most forgiving when it comes to the quote, the stereotypical drunken sailor behavior. They generally understand that's part of the culture, and they generally are more forgiving. So if you're facing a prosecution in the Navy for drunken disorderly type behavior, you have a good chance of getting either a light punishment or a full acquittal. and having a civilian defense counsel may make the difference there in getting the outcome you deserve, which is a second chance and an opportunity to redeem yourself and not face, lifetime of ruin and a federal conviction. The Navy will try to hold you accountable, but panels are generally lenient to the sailors, understanding the stress associated with, if you're locked in a sub for 9 months under the Arctic and you finally get released to civilization, you may act out of character temporarily because of the isolation you just went through. And the Navy is understanding of those circumstances, more so than the other branches, significantly. But what I do see in one pattern that's clear across all branches is just embarrassing prosecutorial incompetence. And that's proven by the statistics. For example, the Department of Justice, their professionalization of their maternity product is just better statistically. Their conviction rate is 95% or higher by jurisdiction. I think the lowest conviction rate of any DOJ office is like 94% if you run the statistics. And across the JAG Corps, the prosecution conviction rate varies office to office between 40 to 60, meaning the absolute best prosecution team only has a 60% conviction rate, and many of them have 40% if they're lucky. That is embarrassing. If you are prosecuting a case and you don't know what you're doing and you don't have the evidence lined up and you're losing more than half of them, and you're losing many of those to the brand new trial defense attorney who doesn't know what they're doing, that means you really are incompetent and your case was super weak and you should not have prosecuted it. The Department of Justice, again, wins 95% of the time. Because, again, they're the government. They have all the resources available to them. And they will only prosecute what they think they absolutely can prove. And they're winning 19 out of 20 times. In the military, the best officers win 6 out of 10 times. And a lot of it's because they just make mistakes that are, lack of better phraseology, laughable or silly, or, a more experienced prosecutor would not have made. But it's certainly... That's been my experience. Let's go into some stories now, some individual descriptions of prior cases. We'll go to war story number 1. All right. This is a great example, and this case fits the description of half a dozen cases our firm has tried within the last 10 years, where the Air Force prosecutes a Article 112, meaning a drug hot. Most of the time in the Army and the Navy, if you are found to have engaged in positive drug use, they don't prosecute that case as a criminal offense. They usually administratively separate you for drug abuse. And it's really simple. They have to show the lab paperwork and the documentation has to be authenticated, and then they establish it, and then you throw you out. It's a pretty simple paper out process. You can fight it. You can get a second chance if they really care about giving you another opportunity, but ultimately it's paper you out and you're done, unless you have a really vigorous defense. The Air Force takes it one step further. They go all the way to court-martial, because they really want to set an example that they have no tolerance. And if they offer you some kind of administrative punishment and you turn it down, they'll prosecute it. So in this case, for example, they were doing an investigation on distribution of drugs by alleged multiple people. And my client happened to date the seller of other drugs, unknowing to him that she was doing this as a side hustle. She was also in the Air Force. He established a romantic relationship with her through some online dating app. They met, they had a relationship, they'd see each other infrequently. It wasn't an official relationship. It was a casual back and forth. We're not really sure what we're doing with this. Well, ultimately, she was arrested for, her side business of selling drugs, and he was caught up in the investigation because her phone showed communication with him. So then they went after him, and they subpoenaed his phone, seized his devices, and they found photos of him with her. And they tried to build this theory that he was also using simply by his affiliation with her. No actual evidence of a positive UA, no actual, possession of any unlawful material. They searched him, they searched his residence, they searched everything. They found basically nothing. They still charged him with drug abuse, though, based on a few photos they found in her phone that apparently showed him. Well, we were able to keep out almost all of the evidence the government thought they had. It was mostly speculation, innuendo, hearsay, and making connections that were just not really there. We were able to use objections under 803, under 901, under 106, and under 304. 304, we specifically harped on, unfair prejudice, confusion of the issues, trial within a trial, undue delay. needless presentation of cumulative evidence, misleading. The backstory here too is they tried to prosecute her for selling and get her on her drug business. And frankly, this was a long time ago, so a few years ago, so I don't think there's any problem with admitting this. She probably was guilty. She wasn't my client, so I can say that. I got to review the evidence from him, and he told me she was pretty much probably guilty, obviously. And they knew that, but they prosecuted her, but they lost. They didn't know what they were doing. They couldn't get any evidence, and she was acquitted. So they were really, really angry that they lost on that case. So they tried to take the anger from that case and get my client, who was her on and off again boyfriend, and make sure he suffered for what she had done. It was ridiculous. But the office was trying to save embarrassment with the command for all the money and time they'd spent on investigating all these airmen who were supposedly buying drugs. And when they lost her prosecution through just sheer incompetence, they then focused double the effort on my client, who had nothing to do with her side business. Ultimately, he was acquitted. And a full acquittal. Took the panel about an hour. They came back not guilty on the charges and specifications that he was facing. And ultimately, again, it shows he never should have been prosecuted, because their quote theory that he was somehow involved in her conduct was only supported by biased theory. It wasn't actually supported by any actual evidence. And she never told anything about him having anything to do with this. They didn't have any recordings of any conversation. They didn't have any witnesses that backed up this. They had speculation and theory. Oh, well, maybe he's there. Maybe he's involved. I saw him with her at one point. Yeah, but she wasn't just selling drugs. She was also in the Air Force. So when they were together, she wasn't engaged in her illicit conspiracy to distribute. She was romantically pursuing him. She kind of kept that hidden from him. He didn't know that she was also a drug dealer on the side. And he didn't have a duty to go find out. He wasn't married to her. He didn't live with her. They put the duty of him to find these things out about her on him unfairly. They lost, and they got humiliated, and they deserved to lose, because it was a ridiculous prosecution. It never should have happened. So that was a great victory, and I still think highly of that case. And I'll never forget, the father of the client owned a business out in California, and he sent me and my colleague Heather bottles of wine in the mail after winning. I'm not allowed to accept gifts like that, so we had to return it, unfortunately. But it was a really nice benefit to have the mail show, hey, you got those big bottles of wine here for celebration. So I'm really, really appreciative of that outcome, and I still think about that case a lot. And it just goes back to showing couple things. The Air Force, they get emotional about stuff, and they don't think rationally. I see that in prosecutions, and that case is a great example of it. If they had any sense, they would have dropped it and saved themselves from the embarrassment. They didn't do that. They prosecuted anyway, and we won. And that was at Andrews Air Force Base too. And Andrews is close to D.C., so you would think that they'd have more oversight. But again, the Air Force, many of them, they see trials as like an opportunity to practice, which is unethical. If you don't have the evidence to convict, you should drop the prosecution. All stop. The next story, War Story 2, another Air Force full acquittal. Again, I'm going to beat up on the Air Force a lot, because they gave me a lot of business, and they try a lot of cases that have no merit whatsoever. This case was a case that what I consider is malicious prosecution. And I'm going to talk about it here on the slides. It was a sex case. So warning, caveat, some of the language I may use may be insensitive to victims of assault. I do not condone inappropriate sexual behavior, and I do not tolerate that kind of behavior at my home or in my office or in my workplace. But I'm hired to defend people who are accused of these crimes, and that's my job. And my job is to provide zealous advocacy to the maximum extent possible. And in that role, my job is to flesh out what I consider allegations that are not supported by the evidence, or lack of better phrase, descript BS cases. And unfortunately, statistics show some people do lie about being victims of crime, and that includes sexual assault crimes. Some people will lie about their car being stolen and say it was stolen when they sold it themselves to a drug lord, and it's in Africa now and it's gone, but they come up with a theory of it being stolen and put on a ship because they want to get paid by their insurance company and get paid by their the drug lord who bought the car. It happens in Houston quite a bit. You see Escalades have a high value premium in Africa. So what they do is they drive the Escalade down to the port, and then they call the insurance company up and say it was stolen in the middle of the night. And they get paid twice. They get paid cash up front for it being put on the ship on the way to South Africa, and they get paid by the insurance company after it's been, quote, stolen. Well, if you get caught with that, you're going to jail for insurance fraud. People do it, though, all the time. People also lie about being victims of sexual assault. Some people say it's only 2% of the time. Some people say it's 20% of the time. I don't know which way it is, but even if you say it's only 2% of the time, everybody would know there's more than 10,000 rape prosecutions every year. So that means there's at least 200 people who are fully innocent who are victims of a complete fraud. That's a lot of people. That's 200 people out of 10,000 who are victims of a pure lie, not a gray area, but an absolute fraud. That's really concerning because that means there's 10,000 people convicted right now in jail for sex assault, and at least 200 of them are absolutely innocent and did not commit that crime. At least 200 of them. That's a lot of innocent people in jail right now. It's really sad, in my opinion. But it happens. It's foreseeable. It's predictable. And in this case, great example of it. Rape is a detestable crime, and it's despicable when it happens. But again, a lot of my cases, it's not. It's more of a gray area of whether a sex assault happened or not. And my job is to defend the person accused. In this case, we had a full acquittal because even the Air Force prosecutors knew the case had no merit. They told me that themselves, but they were forced under duress to prosecute because Congress, in its wisdom of bipartisan incompetence, has come together to be blind to the reality of humanity, in my opinion. This is my editorial. This next couple statements are not supported by anybody other than me and my own personal private opinion. Not the opinion of anybody at Tully Rinckey, not the opinion, I mean, maybe, but not, I'm not, it's not the official opinion of anybody. So what I'm going to say next is caveated by it's only me speaking on as myself, Sean Timmons, attorney at law, Texas bar number 240-67908. Direct all fire at me and nobody else, please. People like Ted Cruz and Kristen Gillibrand are radically different. Ted Cruz being far right, Kristen Gillibrand being far left. But they both agree on putting the military under duress to prosecute ridiculously weak sex crimes. Ted Cruz, because he's a radical Puritan who thinks that all sex out of marriage should be criminalized. So how dare somebody have sex with somebody other than their wife? And if they do, they're probably a rapist and they should be criminally prosecuted. And Kristen Gillibrand, because she's a radical feminist who thinks all sex is rape. And of course, if you are a quote victim, you must have been raped. Those two extreme ideologies of Puritanism and radical feminism have come together in Congress to agree that we should prosecute everything in the military when it comes to sex allegations, which is two examples of far left, far right being so off the deep end, they actually meet and they both fall in the pit together. And that's what you have in the military today. You have the far right and the far left agreeing that we should prosecute stuff that everybody in the sensible middle between the extremes would think and realize is absurd. And that's what we have now with rape prosecutions in the military. Far right wants rape prosecutions maximized because, again, all sex out of marriage is immoral, so how dare they do it? And the far left wants it all prosecuted because men are inherently evil. That's their belief. And that's just, those are absurd extreme positions, but that's what that results in is a significant number of prosecutions under duress that ethically should not be moved forward. And that's what you have case after case after case about in the military, where you have these two extreme ideologies meet and agree to engage in behavior and conduct that makes no actual sense. And that's the exact case I had at Scott Air Force Base. A quote-unquote victim meets my client on Bumble. Well, they meet on Bumble. They meet in his barracks room. They have sex on Friday, Saturday, and Sunday. Monday morning, my client, being the upstanding citizen that he was, discloses to the victim words to the effect of, she tells him, well, I really can't wait to come back next weekend and see you. I really starting to have some feelings for you, really, really enjoyed my weekend. And he says, okay, well, don't come back next weekend. I can't see you then. And she says, well, why? Probably thinking he's going on military duty or something. And he tells her flat out, oh, you were just my side chick for the weekend. My girlfriend's coming into town to visit me. Very foolish, immature, dumb communication skills by my client. Absolutely stipulate he's a total jerk for saying all that. But was any of that disclosure of a crime? No. She gets very, very emotionally aggrieved, very upset, and runs straight to the police to report him for rape after he disclosed that she was his quote unquote side piece. Never tell a woman something like that. It's very demeaning. It's very humiliating. It's very degrading, and it's going to result in an emotional response. And in here, it resulted in his getting his door kicked in, his devices seized, and being hauled off to prison, being released later the day, but still had to be, handcuffed and fingerprinted and mugshotted and everything else, and then released back to his unit, and for 2 years go through a prosecution for a crime that he didn't commit because there was consensual sex Friday, Saturday, and Sunday, and it all came out during trial. But again, because he told her on Monday she was his quote side piece, she was humiliated by that. She went and reported him for quote unquote rape, and her story was really silly. She admitted to the police, to the authorities, OSI, Office of Special Investigations, that she had consented to vaginal. Again, I apologize for the warning, graphic, lewd description of facts here. So children listening should turn this off, and anybody who's sensitive to graphic language should just turn the thing off now. So everybody's been warned. I'm going to continue now. She admitted that the vaginal sex was consensual, but the anal was not consensual. Well, the facts describe they had anal on Friday. They had vaginal again on Saturday and Sunday. So if you were horrified by the anal on Friday, why did you come back for more activity Saturday and Sunday? And that's what won the case. Because, again, this case would not have been prosecuted had old law been in effect. But again, the law has been changed to prosecute everything. Under the Manual for Court Martials of 1969, this case, by law, would not have been prosecuted because the law required at the time force and lack of consent are indispensable to the offense. Thus, I'm going to read this from the law at the time. This is the actual statute as existed for a good 20 years. Thus, if a female consents to the act, is not rape. The lack of consent required, however, is more than mere lack of acquiescence. The woman's mental and physical faculties fails to make her consent reasonably manifest by taking measures of resistance that are called by the circumstances. The inference may be drawn. She did, in fact, consent. Consent, however, will not be inferred from resistance will be futile or resistance overcome by threats or death. Well, the point of the statute here was to describe mistake of fact. He believed, based on her coming back for more on Saturday and Sunday, that everything that happened on Friday obviously was consensual, even if it wasn't. I'm not a witness to what happened, so I don't know. Maybe she agreed to the anal on Friday. Maybe she didn't. But she came back for more on Saturday and Sunday. So that was the end of the case. It should not have been prosecuted. By her agreement to participate and engage in follow-on activity, you have the doubt about whether the initial was legitimate or not. Whether it was legitimate or not, we'll never truly know. And I don't want to be insensitive, but from a prosecution perspective, that lack of inability to know is, by definition, reasonable doubt. Whether he's a good person, no, I'm not saying he's a good person. He's a terrible person because the way he did everything he did was, again, morally corrupt. But being morally corrupt is not being a criminal necessarily, unless the thing that's immoral is also a crime. Well, some codes of morality say gambling is illegal, terrible, and shouldn't be done. And some say prostitution shouldn't be done. Some say all kinds of certain behavior should not happen morally. But some jurisdictions permit that conduct, like drug use, like gambling, like prostitution. In Nevada, prostitution is illegal. In many counties, in many states, gambling's legal. In Texas, it's not for some reason. But it's illegal in most. Gambling legal in most jurisdictions. Most states now have casinos. Many religious people would say those are immoral locations that should not exist. But it's legal behavior. So you can't let your morality cloud your judgment legally. But because of this corruption in Congress and the duress they put on the military, you have a lot of prosecutions on sex cases that are factually, if you follow the mistake of fact doctrine, simply should not be prosecuted. The military established the Office of Special Trial Counsel a couple years ago to review cases specifically for the determination of whether there's merit to prosecute or not. And one of the first things they did, the Army appointed General Wells to be the examiner in charge of the unit to examine the cases to determine if there's merit to the prosecutions. And what happened, General Wells, as soon as they found out he used to be a defense attorney? They fired him. Why did they fire him? Because he previously had wrote that some of the cases he was defending showed the prosecutions lacked merit. So because he dared defend people accused of sex crimes in the past as his prior role, he was removed as the prosecutor for the special trial counsel office. What does that show? That shows Congress is still putting the military under duress to prosecute weak cases, because no member of Congress wants a, quote, victim to come to their office and say the military ignored me and the military refused to give me justice, even if the facts don't line up with reality, even if the facts show, it's a gray area, we can't really prosecute. Even if the ethical duty of the state bar says you don't prosecute unless you have pretty good certainty you can convict, they still would prosecute anyway in the military. And this case, in this full acquittal, I knew this case was a full acquittal from the initial consultation. After I talked to my potential client, I told him, if what you're telling me is accurate, you're probably going to get prosecuted to the fullest extent, go to trial, and you'll be acquitted. And that is exactly what happened. And am I Nostradamus with some prophecy? No. Why was I able to make that determination? Because, again, it's caveated by, if what the facts you are describing to me are accurate, then this is what's going to happen. And he was telling me the truth. He was telling me his version of events, and his version of events were supported by the underlying evidence. The underlying evidence was then admitted into the trial, and the judge took about 15 minutes to come back with not guilty, all charges, all specifications. And in that case, we did a judge alone. Why? And this is the lesson from it. The lesson is, if you have a clear legal victory coming to you on a mistake of fact rape case, you really want to have a judge alone, because a judge will understand the law. Panels will get emotional, and many of them have been corrupted and perverted and desensitized, or been indoctrinated with this new wave ideology that all victims are really victims, and everybody who claims they've been assaulted must be a victim, and therefore everybody who's been accused is automatically guilty. That the Me Too movement really caused a lot of panels to disregard their legal duty to follow the statute and the law, and just go with the idea that, no, we got to hold these people accountable. And I understand that. I truly do, because a lot of victims deserve justice and did not get it. But at the same time, the Constitution protects the due process rights of those accused. And my duty as an attorney to the accused is to make sure justice is done by ensuring their due process is protected and that the laws follow. And just letting emotion cloud your judgment because of a hysteria by a new political movement, unfortunately, can ruin independent assessment of whether somebody is actually guilty or not. So panels have been coming back with convictions on cases, and the prosecutors know this because they just use common phraseology and canned statements and generalized terms, and they've been coming back with convictions because, again, they're caught up in this idea that we need to hold these perverts accountable. And yes, people who are criminal perverts should be held accountable. I don't disagree with that. But just because you're accused of doing something illegal doesn't mean you're actually guilty. The government has the burden. Again, the burden's on the government to prove guilt, not on the accused to establish their innocence. However, in the military, all too often, the burden's flipped, and you're guilty unless you absolutely prove your innocence. In this case, we were able to do so simply through cross-examination. And the key fact from this case is my cross-examination got the, quote, victim to basically admit to the truth of the entire story. And the judge heard the story and realized, okay, yeah, that's what happened, and not guilty, automatically, mistake of fact. Mistake of fact won today. And mistake of fact wins most sex prosecution full acquittals. What is mistake of fact? Mistake of fact, what I described. If you believe there was consent, even if there wasn't, if you reasonably believe there was, not guilty. And I have cases like that all the time. She was naked in the bed. You touched her. Did she officially say, come touch me? No. But she was nude. So you believed you had the authorization to proceed. You found out later she was upset. Okay, but you're not guilty. And I had that full acquittal in Pensacola on those facts. Even after he admitted to doing everything in violation of what she wanted, he was still acquitted. Why? Because, again, mistake of fact. So we'll move on to War Story 3. I'm bleeding into the next case now. And again, I want to emphasize the opinions I express are my opinions only from my jaded, exhausted, just grueling travel schedule and trial work ethic. I have had trial after trial after trial of case after case after case, the same patterns over and over again of predictable human behavior that's very frustrating. For example, for 100 years, DUIs have been outlawed, right? Driving while intoxicated has been illegal. Every single day it happens. And every single day somebody dies from an idiot on the road who's drunk. It is completely preventable, but it happens every day. And I've learned to just live with the fact that there's certain human behavior that's not going to change. And this political theory that we can somehow eliminate rape and we can somehow end sex assault is a delusional fantasy that politicians sell to their constituents for votes. And it's disingenuous and it's illegitimate and it's absurd. And what it actually causes is the prosecution of many individuals who were innocent, who actually didn't do anything wrong, because they're trying to, quote, show they care about justice by holding perpetrators accountable, when in reality, they're making a mockery of the system and neglecting to prosecute legitimate cases properly, and they're just stepping on the neck of the innocent because they want to show this BS that they're actually serious about holding people accountable, which is not legitimate. It's very disingenuous, and it's a fraud. And I can say that confidently because I've witnessed it and I've experienced it for the last 10 years in private practice, litigating these cases. Many of these sex crime prosecutions simply wouldn't happen if Congress wasn't putting the military under duress to prosecute stuff that's weak, and people would look at it objectively instead of with emotion. And unfortunately, every sex case is tied with emotion. Alcohol misuse happens nonstop. Have we prevented it? Have we stopped it? No. Are there programs to reduce it? Yes. And in fact, Uber reduced DUIs so much that many jurisdictions decided to try to make Uber impossible to establish their business. Why? Because the police want DUIs because they make money off the tickets. And jurisdictions would discourage Uber from entering their location because they need the DUI money to fund the police department. It's terrible. But that's the reality of our economic system in our country and our culture and everything else. So a lot of places, quote unquote, want DUI to stop, but in reality they need the money from the tickets that they generate. So they kind of wink, wink, let it happen. The sex cases, military prosecutes them knowing they're going to lose, but they have all these contracts with these vendors for DNA, for forensic psychiatry, for examinations, for hospital. They have all these other perverted reasons to prosecute, even if they don't need to, that are in the background. So if you're wondering why is this going forward to a prosecution, part of it's just the military justice system is inherently built to prosecute, and if they don't, then people aren't going to have anything to do. So they prosecute stuff even if it makes no sense. War Story 3, full acquittal. Again, this is another example, and I've seen this a lot of times. And again, I want to apologize if anybody's offended, but this is a civilian defense attorney talking. I am totally biased, I fully admit, because my job is to defend people accused. I'm not looking at this from a prosecutorial perspective. A prosecutor would probably disagree with 80% of what I've said today. And that's understandable. That's their role, that's their job, that's their profession, and that's their viewpoint. My job as the attorney fighting for those accused wrongly is to provide zealous advocacy. And I truly believe in my zealous advocacy. That's why I get up every day and go to work and fight tooth and nail for my clients to get acquitted and get exonerated. This is a great example of another case that should not have been prosecuted. Quote unquote, victim in a relationship with two different guys at the same time, breaks it off with one guy, and goes to be with the other guy exclusively. So she was seeing two men romantically at the same time and decides that doesn't want to do that anymore, breaks it off with my client, goes and be with the other guy. Well, the other guy's still jealous and upset, so now she didn't want to admit to their promiscuous behavior, so he's a rapist. Happens all the time. And it's very unfortunate, but many times when people are caught in quote unquote scandalous behavior, to inoculate their culpability, they claim they've been assaulted. And there's a lot of history behind this. There's the fact it's really a tragic indictment of American history. A lot of racism is reflected in lynchings that happened 100 years ago plus. And the manifestation of those lynchings that occurred that were completely illegal, unlawful, immoral, disgusting, terrible, never should have happened. How did they start? Because somebody claimed rape, and the community with the torch came and got the quote unquote perpetrator, dragged him out to the street, tied him up by a rope, and murdered him. And the community, there's photos of people like in the community cheering this on. Well, that happened because a female was engaged in illicit behavior with an African American male, and husband or boyfriend found out about it, and obviously she was caught in the act, so if she wasn't consenting, she was being raped, and she would probably cry rape to protect herself from the scandal of engaging in this consensual activity, and the perpetrator would then be murdered. And you have prosecutions today that still follow a similar trajectory. People claim that they're being assaulted to cover up their complicity in a scandalous behavior that they're trying to hide from. It's really terrible, but that's a really sad indictment of our culture that we allowed it to happen, and people were not properly, given a fair trial for proper adjudication on the merits of whether the crime actually occurred or not. And in the South, for a long time, they were just murdered flat out in the community without even being prosecuted by the police at all. In the military, you have a prosecution. People aren't just lynched, but it seems like a high-tech version of it, and it's very, very unfortunate. My client went through 2 years of hell on a case that had no merit. The Corpus Christi police took the complaint and literally laughed her out of the building. Like, get the hell out of here. You're lying. This is totally ridiculous. There's no way this is a rape. You're full of BS. They told her all this. She goes out all upset, humiliated, angry, goes to NCIS, tells them the same story. And what does NCIS do? They robotically follow the methodology of, we have to believe the victim. Doesn't matter how absurd the story might be or how many factual holes are in it. We're just going to take her for her word for it, and let's go prosecute. And they did. And then they worked on building evidence against my client, and they established a pretextual confession. They called my client, had her call. She got him on the phone, and she told him everything about her version of events. And my client, being the gentleman he was, just apologized for everything. And by doing so, by falling into this pretextual phone call trap, he admitted to the elements, basically admitted to arson, if you analogize it. Yes, I'm sorry I burned your dwelling, knowing it was yours, not mine, with the intent to destroy permanently. And I'm really sorry I did this with malice aforethought, deliberately, maliciously, with the intent to destroy. The elements of arson are the malicious burning of a dwelling of another with the intent to destroy permanently. The elements of sex assault fit a similar element by element analysis. He admitted to everything that she was saying he'd done to violate her. Why was he doing that? Because he was apologizing, hoping to reconcile the relationship to get back with her, not because it actually happened. And even if it did actually happen, he mistakenly believed it was legitimate, but he was apologizing because he got it wrong. They used that to try to convict him. We were able to keep it out because the government couldn't get the evidence in. And the exclusion of this quote-unquote confession was dispositive. And the government humiliated themselves in front of the panel multiple times trying to get this evidence in, so much so that the judge took him out of the courtroom and admonished, and you could hear him admonishing the prosecutors through the doors. So they heard everything, even because the doors were, paper thin. And he ripped them a new one about government. Are you totally incompetent? What the heck here? I mean, this is ridiculous. Do you not know what you're doing? Those are the questions the judge asked them. And the government response, of course, was, Your Honor, I get a lot of that in my trials. And when they start doing Your Honor, that means we're winning. And they came back, they dropped it, didn't get put in. Panel got to hear the judge rip them a new one. The panel also got to hear them fumble their opening statement where it was stricken from the record because they tried to introduce discussions of evidence that was already held excluded. And we caught it, stood up immediately. Your Honor, they're talking about stuff that's been excluded. And the judge literally almost blew a gasket. Like his veins were popping out of his head. Like, government, how could you talk about stuff that I already ruled was not admissible? Well, that's exactly what they did in their opening statement. Again, it goes back to the lack of preparation, not paying attention to what they're doing, preparing their case without recognizing the rulings that were already ruled by the court. We won that case, full acquittal. Panel took about an hour to come back, and it was really won because the government fumbled the ball. If the government knew what they were doing, based on his admissions, based on her testimony, it probably could have gotten a conviction because he admitted to what he had done. And Had they known what they were doing, he would be in jail today. He was fully acquitted, and it was because of our advocacy and our efforts to cause the government to fumble the ball. We kept punching the ball out that they had, and we won the case. But again, it goes back, should have been prosecuted? No. But was my client facing a conviction if he had not had skilled counsel to cause the government to make mistakes? Absolutely. Great victory for us, and I'm really proud of that story. And I still have it on my social media of me standing outside the courtroom in Pensacola with my co-counsel and my client cheering on the fact that we had a full acquittal after a 5-day trial. The government made us go through 5 days of proceedings. That's how hell-bent they were on trying to convict my client on something that should not have been prosecuted. And if it was a civilian system like the Corpus Christi Police, it would not have been prosecuted. Again, the military prosecutes stuff that most civilian prosecutors would not dare touch because civilian prosecutors have ethical duties to their state bar. They're worried about their licensing, and they're worried about being held accountable if they move something forward that lacks merit. Military is basically immune from that liability because no state bar is going to tell the military general or leadership how to conduct their affairs. So they're going to say, well, if you were ordered to prosecute, okay, you were ordered to prosecute. I've never seen a military attorney sanctioned for anything they've done in the military courtroom by any outside state bar. They simply don't want to get involved in it. So no matter how unethical and how ridiculous they act, they are basically given immunity. It's not flat immunity, but they're functionally immune. And with that, they act arrogant and they engage in conduct that is wholly improper. And that's exactly what happened with this case. The judge called them out on it, and the judge was very favorable to us because of how inept they were. And we were prepared, we were professional, and we conducted ourselves in a manner that won very good credibility with the court. And filing pleadings with the court that are proper, that are well written, that are prepared, that are intelligent and articulate, get you credibility with the judge. And then when you stand up in court and argue based on what you've already filed, the judge is going to be more inclined to rule in your favor because it shows preparation, it shows attention to detail, it shows determination for the zealous advocacy, and it shows you know what you're doing. And when the government puts stuff written in crayon because they're too busy worried about the military obligation for the physical fitness, then it shows, and that's how we can win cases. But again, if you're going with the uniformed attorney who's also preparing stuff in crayon, then it's kind of washes. And that's unfortunately, I see what happened all too often when people go with just their appointed attorney. Their appointed attorney is doing the same sloppy work that the government's doing, and so it evens itself out. All right, let's talk about this case next. This was a case I just had this past spring, and I'll summarize it with this. Current stock market. Bulls win. If you're a bull, you best long term, you're going to make money. If you're a bear and you're strategic and you realize the market's getting top heavy and you bet against it, you're probably going to do pretty well. Bears win all the time. Bears are winning right now because they realized the market got all-time high and they bet against it. Now they're making money. But pigs are slaughtered. People who get too greedy and way too arrogant, they get absolutely destroyed. And that's what happened here. The government thought they had a slam dunk case. They thought the evidence was so overwhelming, there was no chance of acquittal. And we were able to keep out much of their evidence through the best evidence rule, authentication, hearsay objection, witness credibility. And we were able to do all that. And ultimately, at the end of the day, by over prosecuting and embellishing the charges and inflating the story and exaggerating what really happened, they took a winnable, credible prosecution and flushed it down the toilet because of arrogance, hubris, and just, again, being self-foolish. They charged my client with stuff he did not do. We spent a significant amount of time focusing the panel on the stuff that we could affirmatively prove did not happen, and kind of let the stuff he did do just sit there. And by spending our time getting the panel to laser focus on the government charging 1, 3, 5, 8, 11 with no evidence and just pure speculation, but no actual proof, the panel threw the whole case in the shredder. And I was even shocked to some extent because I told my client, look, I don't know how we're going to get you off on 3. I mean, 3, the evidence is there. They got you. The evidence is there on 6. The evidence is there on 7. The evidence is there. If the government just does their basic job, you're going to be convicted on 3, 7, and 8, and not really much we can do. Just like Steve Jobs, died of pancreatic cancer, had the best doctors in the world as a billionaire. Sometimes people who are dying of cancer, no matter what medical intervention they use, they still die. And it's an unfortunate reality. I have to tell clients, same as doctors have to tell patients sometimes, really sorry, there's nothing we can do. Well, that's not always true. There's always experimental medicine. There's always medical miracles. And in my advocacy, there's always Hail Mary chances. And I'm more than willing to step back on the 20-yard line and throw a Hail Mary pass to the end zone. And in this case, we threw a bunch of Hail Mary passes, and we connected on quite a few of them. And we won. We got a full acquittal on all charges, all certifications at Fort Bragg back in May. My colleague, Ira Rushing, was instrumental in helping me out in this case. Michelle Salerno was very helpful, too, associate attorney who did some motions practice on this case. Our team collectively came together and just took the government's case apart step by step by step. And ultimately, the panel was disgusted by the government trying to convict our client of stuff they knew or should have known they couldn't prove. And the panel's disgust caused the prosecution team to lose all credibility. And when the prosecution lost credibility, it didn't matter if they could prove some of the stuff they had. Because they'd lost credibility and it was proven they were dishonest, the panel didn't trust anything they were saying, and they gave us a full acquittal. So if we could show the government's lying, if we could show if they're embellishing, if we could show that they can't prove what they allege, we can cause them to lose credibility, and we can win the case. And that's exactly what happened there. And that was the victory. So how did that happen? Aggressive advocacy and focused determination and diligence, perseverance, and just outworking the government. And that's what happened there. And by doing all that, we were able to get a really good outcome. Is that possible in every case? No, but sheer grit and fortitude, it happens frequently, and it was able to happen in our manner, and we got a great outcome. So in summation, it's a privilege to speak to everybody here. Thank you for listening to this presentation. And again, my apologies for anything that was said that was insensitive. It was not intended to be so. Again, the expressions of my opinions are from a gray-haired, wrinkled, gruff, old, back-hurting, pain-inflicted litigator who travels 100 days plus a year, who lives in jet lag. So with that mindset of jet lag, exhaustion, and battle-hardened fatigue, I'm a little gruff in some of my statements, and a little calloused in my hands of fighting, because I've been in so many battles that, I really shouldn't have had to swing a punch, but I had to for my client on their behalf, because it was necessary to protect their rights and give them the best possible outcome and fight for them for the duration. But was it necessary? No. If the government had been reasonable, it wouldn't have been. But they forced our hand, and we fought every step of the way. And that's what I do day in, day out for my clients who are facing accusations in court martials around the world. I have multiple trials coming up and plenty of room to take on more work. So if you or your loved one find yourself in a predicament where you're facing prosecution and you want an aggressive advocate, we're blessed and privileged to fight on your behalf. And we look forward to helping anybody out in this predicament. And if you are a member of a family whose loved one is facing military prosecution, you really should volunteer your resources to help them out. This is a noble thing to do. And the military system is structurally unfair, and it's unjust. And the only way to even the deck is to bring in private civilian attorneys outside the system. I have no duty to the military. The attorneys assigned to trial defense have to wear the same uniform as the prosecutor, get paid by the same government, and have to play golf with the same people. I don't play golf with anybody. By the time I show up at an installation and I go there and make everybody angry because we win a case, by the time I go back there again, usually it's new people. They don't know who I am. So I don't care about going to a location and making everybody upset and angry because we fight for our client. The people who have to live there for 3 years at a time have to be nice to the other side because they have to sleep in the same location, and they really don't want their tires slashed or their house raided or other reprisal that they could experience if they fight too hard. I have really no worry about reprisal or retaliation, and we're not afraid to hold the government accountable, and we fight because it's the right thing to do. So if you want to get a hold of us, that concludes my presentation on this, war stories from a older litigator. Time has really caught up on me. I didn't realize I've been a lawyer now for almost a couple of decades. I've been practicing law for a while. I've been at Tully Rinckey for about 10 years. I have over 100 trials under my belt experience. I average about one trial every 6 to 7 weeks. Sometimes once every 2 or 3 months, sometimes docketed probably once every 3 or 4 weeks. Many cases get resolved before trial, but the ones that actually go to trial, I have several per year, and full acquittals are a great outcome. They don't happen in every case, but when they do happen, the pattern is reflected by the presentation today. Again, this was a generic presentation. I can't really go into details too specifically because of attorney-client privilege communication and confidentiality requirements to protect the innocent and protect my clients. But I do want to thank all my clients who have retained me in the past, who have trusted me with their life, because it's been a privilege and a blessing to have the opportunity to fight for them every step of the way for the duration as they go through this ordeal in this prosecution by the government, which can be the most stressful experience in your life. So we're here in Sugar Land, Texas, which is in the Houston metropolitan area, but our offices are located coast to coast, New York to California and everywhere in between. And we have 24 veterans on the staff now. I'm one of the JAGs, or former JAGs with trial experience. We also have Ira Rushing, Joe Wilkinson, Michelle Salermo, Eric Duncan, Tony Kuhn, Steve Jewell, many other people too. You can look at our website. I just named a few of them that I work with on a day-to-day basis. And we're all, Jonathan Gonzalez. We have several veterans and people who handle military justice matters. And I spend a significant amount of time on the road for Tully Rinckey in base to base, place to place, case to case, fighting for those needing justice. Thank you.